So welcome to the detention docket for October 6th, 2020. In compliance with the Texas Supreme Court Order number 25, we are not conducting in-person court proceedings, but using the remote application Zoom. We comply with Tarrant County Judge Glenn Whitley's order of closing the courtrooms to the public. The courtroom is closed, but also we have to consider Article 1, Section 13 of the Texas Constitution, which provides for open access to the courts for the public to view the proceedings. So we are broadcasting these proceedings online on YouTube. So no portion of this video or this hearing may be broadcast, recorded, or published. Violation of this order is punishable by contempt of court up to a $500 fine and 6 months in Tarrant County Jail. And so, just to let everyone know, starting October 15th, the court is going to require anybody attending these Zoom sessions to have their cameras on. If you are here just to observe, then the court will ask you to observe from YouTube, which is readily accessible. Today, up until the 15th, it's just optional for anyone who wants to be here quietly with the camera off or not, but just kind of giving everyone notice starting the 15th. That's going to be the new policy for Zoom proceedings. All right, so we'll go ahead and start with Benito Mendoza. I think Tarrant County Jail. Hello, Mr. Mendoza.
Yeah.
Mr. Adler, you're here?
Yes, Your Honor.
Great. All right, so Mr. Mendoza, this is a detention hearing. You've been in custody for 10 days. We need to decide whether to keep you in custody or to release you. If I keep you here, you have to see a judge every 10 days while you're here. You are 32 years old. I remember this case. Oh, you have a right to remain silent. You have a right to an attorney. Mr. Adler has been appointed as your attorney. Mr. Mendoza, I remember this one. This is one where you were arrested. You were found unfit to proceed. You were sent to Mejia. You were released. You were brought back here and then sent back to Mejia. And then while you were there, you were released and you absconded. And you were most recently caught on the border trying to abscond to the Republic of Mexico. And there is a certification petition filed. All right, so Mr. Mendoza, my concern is if I was to let you go, since you were caught trying to leave the country and escape the jurisdiction of this court, I'm concerned that you will try and do the same thing. And so I just have to detain you as a matter of that concern. So, Ms. Aguirre, do we have a date for the certification set?
No, Your Honor, we do not.
Okay. Okay, we're waiting on a psychological evaluation for Mr. Mendoza. Okay, so Mr. Mendoza speaks very little English. Is that?
Yes, Your Honor.
All right, Mr. Adler, if you can just explain to Mr. Mendoza what I just said, and so he understands.
Judge, before you hopped on, I had explained it all to him.
Okay, well, good.
Previously.
All right, thank you, Mr. Adler. I appreciate your efficiency. All right, so I'm going to go ahead and detain you because I'm concerned about you absconding to the jurisdiction of this court. Thank you.
Thanks, Judge.
All right, Adrian Alvarez. Sorry? Okay, good. Hey, Deputy Sheriff, thank you very much for bringing Mr. Mendoza here. Y'all have a good day.
Thank you, Judge. Yes, sir.
All right, Mr. Alvarez, I'm Judge Kim. This is a detention hearing. The law says when a child's brought to our facility, you have to see a judge within 2 days, and I have to decide whether to keep you here or to release you. If I keep you here, the law says you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. You can afford one. We'll provide one for you. Mr. Gladstone, in the interim, has been appointed as your attorney to assist you. All right, so Adrian, you're 16 years old. You are, let's see. Well, you were placed on DPP for an unauthorized use of a motor vehicle back in February. So we placed you on DPP on October 5th. And then on the day that you were placed on DP, deferred prosecution, you left the home while on electronic monitor. Family said there was a misunderstanding and grandma gave you permission to go to the store to get your phone fixed without knowing she had to clear time with a PO. And we gave you a drug test and you're negative. All right, so I am glad you're back. All right, Mr. Alvarez, you speak English, correct?
Yes, sir.
All right. You understand how serious I am about the rules of probation and about deferred prosecution?
Yes, sir.
Okay. You understand that when there's a limitation on you about you can only leave with permission on electronic monitor, it is ultimately your responsibility, no matter what grandma says, for you to follow the rules that are imposed upon you, right?
Yes.
Okay. So going forward, is there any confusion or question on your part of what you need to do?
No, sir.
Okay. All right, so I'm gonna go ahead and give you another chance. This was a quick come in to make sure. I'm glad you're negative for weed, because I can tell you right now, if you're testing positive for weed, I'd be detaining you, okay? So go do the DPP, finish, get this all behind you. It's not probation, it's just DPP, all right? They want to give you this chance, thinking this was just one mistake, all right? Just prove to us, though, it's just a one mistake from your past. You're older, you're more mature, you get things now, you're not gonna be a problem for us, okay?
Yes.
All right, thank you, Mr. Alvarez. Ms. Rodriguez, thank you for bringing him in. I think it was really important just for the consequences to be immediate.
Thank you, Your Honor. Señor
I can
Alvarez,
release
¿se
him.
encuentra afuera?
We're gonna release him on electronic monitor. This time, hopefully he'll make it 24 hours. All right, next we have Nathan Gonzalez. All right, Mr. Gonzalez, please take your hoodie off. You're inside a courtroom. All right, Mr. Gonzalez, this is an out of custody detention hearing that I've requested. All right, I need to make a decision whether to take you into custody or to keep you in the community. If I take you into custody, you have the right to see a judge every 10 days while you're here. You do have a right to remain silent, and you have a right to an attorney. If you cannot afford an attorney, we'll provide one for you. Mr. Shaw was your appointed attorney. He is unable to make it today because of a conflict. Mr. Adniji, I'm asking you to step in. Mr. Adniji, can you introduce yourself so he sees you?
My name is Latif Adeniji.
All right. Do you see him, Mr. Gonzalez?
Yes, sir.
Okay. All right. So, Mr. Gonzalez, currently, let's look at this. You're 14 years old. And then back in November of 19, you were arrested for criminal mischief, which you got supervisory caution for. Then December, a couple weeks later, you're arrested for assault of a public servant, which you got deferred prosecution for. And then here in June, about 10:30, Officer Whitman of Fort Worth PD saw a young white male wearing a red shirt, red hat, place a handgun in his waistband in front of the food mart in West Fort Worth. They were looking through the cameras that were surveilling the area. When police got there, they found the juvenile went inside the store. They found him near the drink coolers in the back. They told him to keep his hands visible. They did a pat down and found a .380 caliber pistol. The police took possession of the handgun, which was loaded with a loaded magazine and one in the chamber. And so he was arrested and brought here. So, let's see. We released an electronic monitor on July 21st. So, Mr. Thomas, he was arrested June 22nd and then released July 21st. What took him so long for the release?
Your Honor, we did obtain during that time a psychological evaluation, and I believe that his courts had been passed throughout there, and we are scheduled for our next court hearing for October 15th.
For October 15th?
For October 15th, yes, and
Okay.
as well as the filing. They were wanting to also file, I think they amended to file on the deferred prosecution, the reopen.
Right. Okay. So then the question is, was he on electronic monitor?
Yes, he has been.
Okay. Is he still on the electronic monitor?
He is, and he has not had any violations since release on the 21st
Okay.
of July.
No violations of electronic monitor, but Mr. Gonzalez is aware that he's not supposed to associate with anybody who has a pending case or on probation. Is that correct?
That is correct.
Okay. So here's the problem, Mr. Gonzalez, is that you're not supposed to be associating with people that are on probation or have pending cases, like Mr. Moore, right? This is a violation of your release, right? You're not supposed to associate with that. And so that is clearly you. You're even wearing the same mask right now as you are in this picture. All right, the level of self-snitching that's going on right now is just unbelievable. But I'm letting you know the worst thing that you can do, I mean, it's bad enough that you're gonna go ahead and break the rules and violate the terms of your release. But it's another thing when you're actually publishing that, you're letting pictures taken of you and publishing that on the internet. Okay, so anyways, so I'm finding that you're a danger to the community as well as yourself. You're associating with, you're here on a gun charge. You're also associating with other people with gun charges or shooting charges. And so I feel like you're a danger to yourself and the community. I'm gonna go ahead and detain you. All right, Ms. Thomas, let's go ahead and give him a drug test and see what happens there. I'm pretty sure he's gonna test positive. But Mr. Gonzalez, you have to understand that rules are rules. Either you follow the rules or you don't. And I hope you understand for your level of offense, you could be committed to the Texas Juvenile Justice Department. That means they could hold you there up until your 19th birthday if you're not gonna follow the rules. So at a certain point, you can decide to follow the rules and stay at home with your mom, or you can not follow the rules and you end up in and out of the juvenile justice system until your 19th birthday. All right, Mom, did you happen to bring your medications with you or his medications?
He's not on any medication except his inhaler.
Okay, do you have that with you by chance?
Yes, he does.
Okay, so please give that to Ms. Thomas so we make sure he gets the medication that he's prescribed. All right, Mr. Gonzalez, I don't know how long you're gonna stay here. We're gonna see what your behavior level is like. Hopefully this is a minor correction, but you have to understand that rules are rules. And you were told not to associate with people that have pending cases or on probation. You chose to do so with multiple people. And so because of that, this is the consequence to your decision. Good decisions come from experience. Experience comes from bad decisions. You made some bad decisions, make some good ones, and we'll see where we go from there. All right. Thank you, Mr. Gonzalez.
Judge.
All right, Bryce Jones. All right, Mr. Jones, I'm Judge Kim. This is a detention hearing. The purpose of this hearing is to make a decision whether to keep you here or to release you. If I keep you here, the law says you see a judge every 10 days while you're here. You have a right to remain silent, and you have a right to an attorney. If you or your family cannot afford an attorney, I'll provide one for you. Thank you, Mr. Green. All right, Mr. Jones, so you are 16, you're almost 17 years old. So in less than a month, this all started when you're 9 years old with an intervention hearing.
Yes.
So now you're 15 with an
Yeah.
aggravated robbery, which you got probation for, and placed on probation, involved a handgun. And I placed you on probation. All right. So then in April, while you're on probation, you pick up a terroristic threat against a public servant, which got added to your probation. Then we had a couple violations. Then in May of this year, you got arrested for unlawfully carrying a weapon, which you got probation. Stephanie, can I find out which judge signed the order that gave the probation on May 20, is June 23rd, or maybe the probation officer knows. Ms. Washington,
Yes, sir.
you know which judge granted the probation on June 23rd, 2020 for the UCW?
Let me look and see on the 23rd. Porter, Judge Porter, Your Honor.
Okay. So, all right, so you're on probation for aggravated robbery. Then you have a terroristic threat against a public servant, which is added to probation. And then you get arrested for another gun charge, which you got added to probation. And then now, let's see.
He
This morning at
completed.
1 o'clock. I'm sorry?
He did complete the previous probation, so he's just on the unlawful carrying of a weapon right now.
Okay. All right. So this morning at 1 o'clock, you turned yourself in on a warrant that Judge Porter had signed for not contacting your probation officer. You're on probation for UCW for a 9mm handgun. And you didn't make contact with your probation officer on August 7th, 10th, 12th, 13th, 17th, 19th, 20th, 21st, and 24th. Let's see. We received a referral. Let's see, saying that on August 16th, police were dispatched to a convenience store in Grapevine about a stolen vehicle. The victim stopped by the store to get coffee, left his car running with the keys inside. While he was in there, two black teens walked in behind him. One of the black teenagers was wearing a white t-shirt and black or gray shorts. The other had a black top with dark pants. The black teenager with the white attempted to grab the wallet from his hand but failed to take it. The victim backed up and the teenagers walked out. Then he realized his car was missing. He went inside, got the video, saw all three suspects in the video. It was all captured and had a recording of you. So you came in and we give you a drug test and you're positive for weed. So now you're looking at theft from person felony charge. All right, Mr. Jones, here's the deal. I'm absolutely convinced if I let you go, you're going to try and rob somebody else or have another gun or shoot somebody or cause more problems. So if I kept you here, it's the only way to protect the community from you and from the community. Because one day somebody that you're trying to rob is going to have a gun, is going to kill you on the spot. So anyways, you're being detained. Thank you, sir. Decorium Montague.
Thank you, Your Honor.
Thank you. All right, Mr. Montague, I'm Judge Kim. This is a 10-day detention hearing. I'm here to decide whether to keep you here or to release you. If I keep you here, law says you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. If you cannot afford an attorney, I'll provide one for you. Ms. Keenan, your attorney is here. Ms. Keenan, can you say hi?
I'm right here.
All right, do you see your attorney, Mr. Montague?
Yes, sir.
I'm sorry, Ms. Perkins.
It's okay, Judge.
Okay. Oh. I know she is. It was like that with Corey Andrews. I called her Andrews until, well, I'm not gonna jinx me with the story. All right, so Mr. Montague, on August 23rd, you're brought in. Let's see, but you're Taliban, right?
Yes.
Okay, you're sure. All right, so we issued a warrant for you in January when you cut off your monitor, and let's see, cut off his monitor because he was on probation for unauthorized use of a motor vehicle. Okay, so the police officers were patrolling one of your friends hanging out at a convenience store. When the officers got to the parking lot, they saw you sitting inside a car and they recognized you as somebody with a homicide warrant. So everyone was detained at gunpoint. You disobeyed several commands to put your hands up, and they saw you passing something to a female in the back seat. And finally, you revealed your hands, taking it custody, and you said that there was a gun. You gave them the location of the gun in the vehicle. Pastor confirmed that the gun was placed in the floorboard by you. Your name was run through the system and found a homicide warrant for you out of Fort Worth, as well as UUMD. So they brought you over here. According to the warrant, May 26th, detectives were notified of a homicide from Fort Worth. When they got there, the responding officer said that he was flagged down by a black female who was standing over the body of a black male who was lying in a pool of blood. The victim was identified. She said she told the officer that two black males in a red Ford were involved. The victim was pronounced DOA with a gunshot wound to the chest. They told the detectives the victim was called to the car of the suspects, came back a short time later to get $40 and walk back there. After saw the suspect's vehicle drive away, victim on the ground. There was video surveillance. They got the license plate. They tracked down the owner of the car, who said it was her son's car. And turns out that Ape Gang Taliban was later identified. When he sat at the store, victim approached to sell some weed. When he came back, he accidentally accelerated the gas. The victim jumped into the car, and the victim grabbed the gun that was in the car. And it was just a mess. And then, like, Ape Gang Taliban shot him. So, all right. So it looks like, what a mess. For a $40 weed deal. All right, so let's see, probation officer is assigned. Tried to do an administrative hearing with your mom. Hearing was about your school attendance, leaving home without permission, not doing substance abuse treatment, and continued drug use. Put you on electronic monitor, gets compliance with attendance and leaving the house. You cut off your EM, and then you absconded. So we called mom several times, asking her to turn you in, and then she failed to notify us whenever she saw you. So.
Your Honor, he has been on level 1 for quite some time. He got back up to level 1O. He was on level 1A last week. He has been doing really well in detention. And our hearing that was supposed to be handled tomorrow has been canceled and moved out for a status conference on 10/26, which means he would be still in here. And I know we're still missing a lot of information. In fact, I just emailed the prosecutor about that this morning. So I was going to ask if he could be released on an EM to his mother again. I think that mom understands that he cannot abscond. He has to obey all of the rules, and DeCorian understands that too, because he and I have talked about that.
Right, and I appreciate you advocating for your client. Here's the problem is when you set up a pattern of behavior, DeCorian, I'm really kind of talking to you. When you set up a pattern of behavior of cutting off your monitor and running away, you're not at home, you're not calling back the officer, you're not where you're supposed to be, you're skipping school, you keep on picking up new offenses. I can only go on what you've done in the past, right? You set up this pattern of behavior to tell me that if I release you, the community is in absolute danger. And you're in danger, you know, because just as easily you could have gotten shot as well, if in fact that capital murder is true. Right? So at this point, actually, can I see that again? So, and that's one thing that I think for you, it's not necessarily your fault, but you just didn't understand that when you have all these previous things, especially these weapons cases, then it tells me in the future, the next time you come in here, to be extra cautious every single time. So, you know, juvenile is great for those kids that make one mistake and then it's behind them, they're done, because I give every kid the benefit of the doubt. But when they keep on messing up and keep on having problems and keep on breaking the rules and violating their probation, that just tells me probation is not for you. So it just gives me great concern. You know, I don't think you understood that it's not like you get a fresh start every time you come in here. I look at what you've done in the past and I actually hold that against you, right? And it's not just you, it's every kid that comes through here. If you've had a history of running away, disobeying your parents, smoking weed, picking up cases, then every time you come back here, I look at that and I consider that as part of the process. It's not like you get a fresh slate every time your probation is done. I consider the past probation you've been on to decide whether to release you or not. And I think that's just something maybe you didn't understand, but given the fact that you have this one case and your history of cases, that tells me what I need to do is detain you. Right? So I'm going to go ahead and detain you. I appreciate you being level 1. You have to understand that there's a long play on that. You need to give your attorney as much as possible to work with on this case. Right? Because if you're acting a fool back there, like level 3, then the DA is going to bring all that up. And that's going to come in when a decision has to be made, whether to send you to TJJD or not. Are we looking at certification on this one? Do we know?
A certification was filed yesterday. I got the petition late, yesterday afternoon.
Okay. So, Mr. Montague, what you have to understand, the certification means the district attorney is asking me to give up my jurisdiction over you, okay? And send your court downtown to the adult courts where you could be looking at 99 years, all right, on this offense, or life in prison. And so you cannot get the death penalty for this one, but you could get life without parole on this case. You have to understand that if this case does get certified, that you need to establish everything that you can to help your attorney, whether it's Ms. Perkins or another attorney, if it's moved to adult courts, on defending you. And the worse you act back here, the worse it's going to be, because you can imagine the district attorney would be more than happy to show the jury, if you're convicted of the capital murder, all this history of you misbehaving, getting in fights, being violent, being disruptive, all these things back here, you can be sure the district attorney will bring it up in the adult court if they can. So you're right now fighting for your life on getting a chance on probation or getting out of TDC if you are certified and if you are convicted. I can't stress how serious this is, but you could literally spend the rest of your life in prison. Okay. All right. Thank you, Mr. Montague. Cameron Newton.
Your Honor, this young man and the next young man are on DNA. It'll just take us a minute to switch them out.
Okay, thank you, sir.
Good morning, Your Honor, and we have no parent here. I informed the grandma of the detention hearing this morning, but I just checked and she hasn't logged in.
All right. All right, Mr. Newton, I'm Judge Kim. This is a detention hearing. You've been here for 10 days, so I'm reviewing your case, decide to keep you or to release you. If I keep you here, you have to see a judge every 10 days. You do have a right to remain silent. You have a history, you've been held here, and now you're level 3 confined. So I'm going to go ahead and detain you. Thank you, Mr. Newton. You have Riley Holland Stallings. No, I'm
Thank
sorry.
you, Your Honor.
Thank you. Okay, actually, so now at this point, we're going to go ahead and transfer over to Judge Terry before I come back for the under 14-year-old later. Thank you.
Thank you, Judge Kim. Riley Stallings. Hey, Riley, this is your 10-day detention hearing. You know, the purpose of this hearing is to determine whether I can release you to a parent or guardian, or if I should keep you here detained. You have the right to remain silent, but if you do choose to speak, nothing you say can be held against you at any other kind of proceeding. I can only consider it for detention purposes, and you have the right to have an attorney present. And I don't see Mr. Edeniji. Can you step in, please? Ms. Hamrick is not on today. Thank you.
Judge.
All right, so you see Mr. Edeniji, he's going to be your attorney today. Okay, Riley?
Yes, ma'am.
All right, so let's see. Oh. Let's see, this is your second 10 days since you've been back. We just released you on an EM. I remember I saw you the last time.
Yes, ma'am.
Mom, you left off, so Mom couldn't even bring you back, but then you finally came back on September 4th. All right, and your level 1 outstanding as of the 2nd, so for the last 4 days. Mr. Miller, what was he doing before that?
In detention, Judge?
Yes.
He was on level 1 O for the most part, except on October 1st, he had inappropriate language talking without permission. So he went down to 1A for 1 day and then came back up.
Okay, and he's been back up ever since.
Yes, Judge.
And so if he were to be released, he could continue his FFT.
Yes, Judge, that's the plan right now. We were looking at FPP, but they wanted him to finish that program before we made a referral to them.
Okay. And so, all right. Did you like being here, Mr. Stallings?
No, ma'am.
Would you rather be home on that monitor that Judge Porter was trying to get put on you?
Yes, ma'am.
Are you going to behave level 1? Wait, do we have a parent or guardian here for him?
Mom said she was going to be online, but I don't see her.
Okay. I don't. There was someone named Ashley that was jumping on and off earlier, so I don't know, maybe she was at work or something and had to jump back off because I think that was his mom.
Yes, ma'am, that is.
So, all right, I will release you on a monitor And I expect that you won't burn us this time.
I will not.
All right, Riley?
Yes, ma'am.
I'm gonna tell you what, you're gonna end up having a much longer visit the next time.
Yes, ma'am.
You, all right? All right, thank you.
Thank you.
You're lucky day.
Thank you, Judge.
All right, Christian Mays. This is your 10-day detention hearing, and the purpose of this hearing is to determine whether I can release you to a parent or guardian, or if I should keep you detained. You have a right to remain silent, but if you do speak, nothing you say can be held against you at any other kind of proceeding. I can only consider it for detention purposes. You also have a right to have an attorney, and your attorney is Ms. Johnson. Do you see her here on the Zoom screen?
No, ma'am.
Okay, Ms. Johnson, if you unmute yourself and speak up, your box will highlight and he can see you.
I thought waving would work.
Can you see her now, Mr. Mays?
Yes, ma'am.
All right, thank you. Well, it's my lucky day, actually. Let's see, Mr. Mays, you have been, this is your first 10-day hearing, and you are reached level 1 outstanding as of today. So, Ms. Paxson, what's been going on since he's been here?
Your Honor, he has been mostly on level 2. He was placed on 2 unacceptable on the 2nd for not following instructions, talking about fighting and guns, asking about a murder charge. Then he reached 2 acceptable, 2 outstanding, and then 1 outstanding today.
Okay. He's asking other people about their murder charges?
I'm not sure. It's not clear in the notes.
See, I know, Mr. Mays, our standard is level 1 outstanding in order to be considered for release, and I have considered that. The fact that you were mostly on level 2 since you've been here, and the reasons I've been given tells me that I should be concerned about what you're doing out there in the community, or what you're interested in out there in the community. So I am concerned that you are likely to reoffend because you can't simply follow the rules here for a consistent period of time. I need some consistency out of you. So I'm going to go ahead and keep you detained, and I would encourage you to stay on level 1 outstanding, because that way you've created a pattern so that the next time I've seen you, you will have shown me that you can follow the rules. Okay? Thank you.
Thank you, Judge.
There. EM. Yes. All right, Mr. Ruiz, this is your 10-day detention hearing. Purpose of this hearing is to determine whether I can release you to your parent or guardian, or if I should keep you detained. And do we have a parent or guardian present here for him?
Parent is on their way, Judge.
Okay. You have a right to remain silent, but if you do choose to speak, nothing you say can be held against you at any other kind of proceeding. I can only consider it for detention purposes. You also have the right to have an attorney, and I do believe Mr. Masick is not here today. And so, Mr. Edgeniji, if you could jump in again.
Yes, ma'am.
All right. So this is your first 10-day detention hearing since you have been back with us. I think back, I'm going to have to do a recap on this one because this is one of those convoluted ones I recall. All right. came in on September 21st. You were positive for marijuana, and you have your first setting for adjudication dispo set for October 19th. On 8/12, you were referred out of custody by Fort Worth PD on a charge of burglary of a habitation. According to the police report, on the 2nd of August, police responded to a home and a burglary in process. Call indicated 2 female teens were at home while their mother had gone to the store. Girls called their mom and said the Hispanic male was inside their home without permission. Mom called the police and ran home where she found her $2 hiding in the back room. One of the female teens told police she saw a guy in their home known by the name of Stitches. She told police where he typically hangs around. A couple days later, police began searching for Stitches on Instagram and found 3 individuals using a combination of numbers plus the word Stitches, you being one of the 3. One of the victims identified one of the 3 suspects in a photo. And one of the alleged suspects was eventually arrested, another one of them. He admitted to burglary habitation and gave the names of the other 2 individuals. Oh, that's right. So he snitched on you. Okay, I remember this now. And then on the 21st of September, you were transported here on a warrant for engaging in organized criminal activity, burglary of a building. That's right. And so that was on the 1st of August, where it says that you were involved in a burglary on a beauty salon. All right. Is that mom here?
Yes.
Sorry. Let's see. I did ask you to be a one outstanding, and you have been there. Or all right, Mom, are you able to keep an eye on him at home?
Yes, and his old brother is helping me out. He's able to help me out with him also.
So here's a problem, Mr. Ruiz. You've shown me now you've got a supervisory caution previously over a year ago, burglary of a vehicle. And then that's pretty consistent with the type of offenses that you have now, but you seem to be escalating it. You have been level 1 outstanding for the last 10 days. It tells me you know how to at least follow the rules, right?
Yes.
Okay. I'm going to release you to your mom, but you are going to be on a monitor. Is he enrolled in school, Mom?
No, not yet. That's what I'm gonna be working on. See if I could get him in school or get him online school.
Okay. If he's enrolled in school, he's allowed to go to school, and that's it.
Okay.
Okay, that is it. And Mr. Ruiz, if you aren't to have any contact or communications at all with Fidencio Ruiz.
Your Honor, that's his brother.
Oh, that's right. This is the brother. That's right. And isn't his brother older?
Yes, he's in jail. He hasn't bonded out.
But okay. And the brother lives at home?
Yes, Your Honor, I believe so.
All right, so here's what we're gonna do then. Obviously, I can't do that, so you're definitely going to submit to random UAs. Hanging out with your brother and you're coming in here and you're testing positive for marijuana. Is there any relation to Leonard Rosales?
Wait, what was that?
Is there any relation to Leonard Rosales?
No, Your Honor.
Okay, no contact with Leonard Rosales at all. Not social media, not text messages, not phone calls, no notes on your doors, not even through your brother, okay? That's that. If you do that, that'll be a violation of your conditions of release. So, all right, Mama, you can take him home on an electronic monitor. All right,
Okay,
thank you.
thank you.
Thank you, Judge.
Welcome.
Thanks.
Name Leonardo Rosales? Yeah, Leonard Rosales. Hey, Wesley Smith?
Yes, ma'am.
All right, this is your 10-day detention hearing. Purpose of this hearing is to determine whether I should release you to a parent or guardian or if I should keep you here detained. Do you have a parent or guardian here for him?
Judge, his brother had to go to the doctor today, and so his mom wasn't sure if she was going to be able to hop on or not,
Okay.
because it's the only time they could take him. So hopefully she'll be here. If not, she won't.
Oh, well, then you know what? He's level 3 unacceptable. And so that makes it very easy for me to do today, to decide today.
Judge, I think he's level 3 outstanding, and I understand, you know, the first position on the level. Wesley understands it. He and I've talked about it. All my clients and I've talked about it. But for Wesley, 3 outstanding is really well. His family's very concerned he's not getting services while he's in detention. They would like him to come home so that they can get him into some counseling, get him whatever, because no one thought he'd be here this long.
Right, I didn't either. But the problem is he's pending a psychological assessment, and I want to make sure that that gets done. And I don't have a parent here to talk to me today about that. When is that scheduled for? Do we know?
Your Honor, that'll be October 25th. That'll be the 25th at 9 a.m.
And so what's he been doing back there to get him on level 3 level 3 acceptable? I'm sorry.
Well, Your Honor, there's a huge list that includes talking to peers in cafeteria, not doing his schoolwork, over playful, inappropriate language, talking without permission, contraband in his room, continued disruption while in his room, and the list goes on and on and on, Your Honor. I mean,
Judge, the contraband in his room was books. And this has been a thorn in my side for years, that they get in trouble for having books. You know, I mean, I think that, I don't know, I have problems with the rules back in detention. I really do. I don't think these kids are here for vacation. I don't think they're here to have fun. But I also think that sometimes the rules are such that the kid just isn't going to care. But, you know, I still have the argument that his parents are concerned he's not getting services here. They would like to get him out. They don't believe that this system is helping him now. October 25th is forever away. His parents will make sure he gets here for that psych eval. And
What was he? Did they have him in any kind of programs before he was here?
He
Counseling?
was
Anything?
He had just started probation. He's been in counseling before. He's been in hospitals before. They've always done what they can for him. Wesley has a hard time, you know, regulating his behavior. And his mom is here now, I think. Yeah. And Lynn, I was just telling him how you guys are worried that he's not getting services, that you would like him to come home so that y'all can provide that, that he's probably not getting.
Here's what I would like to do, Ms. Abels. No one is, I'm not about to release him on a chance that he might get services when he gets home or whatever. There needs to be a solid plan so that I can have a very specific order releasing him if I were going to. I'm not saying whether that's what I would need as a plan, because right now we have a plan here. I don't know why it's going to take so long to get his evaluation done. I don't know why it's not going to happen until the end of the month. Well, that tells me his court setting is going to be put off too, since his evaluation isn't even done until the end of the month. So I don't like that. But right now, I don't have enough in front of me to decide that he would not be a danger, that he would actually get the treatment that he needs if he were to go home pending these offenses. So I do need a plan. If you guys can get that together and want to present an out of custody to one of us, or not out of custody, I'm sorry, attorney requested in front of one of us, you can do that. But for now, there isn't a plan, and he's on level 3. That's all I have to go off of. And to be honest, I don't even really care about the books that much either. That was kind of the one when you told me that. I'm not worried about that much. I'm worried about his unpredictable and behavior and the constant need, and constant inability to follow the basic directions. I worry about that being able to be handled at home if he's doesn't have services to get done.
Judge, he has a bed. My understanding is there's a bed at TYRC for him. He was supposed to go there in September, and I don't know why he didn't go. I don't understand that. But I'm sure there's a reason. Mr. Reyes, does he still have a bed available there?
Yes, and that day has been changed because he picked up a new offense, assaulting the probation officer in the back, the detention staff. So TYRC is a little bit concerned. The last time I spoke to Mr. David Miracle and about his behavior, they just want to see something is done through us first, and then they want to have the assurance that he's not gonna be acting up when he goes to TYRC and do another assault.
That's my order. That's what happens He's like ruined that chance. So he's detained for now. If you guys can come up with something before the next 10 days, then go ahead and present it. An attorney requested hearing, but I need a solid plan. So.
Okay, I need to know how we give assurances he's not gonna do that. I'd be nervous giving you assurances I wouldn't lose my mind on somebody. So how am I
need to have, like, mom's got to say, I can admit him to this place today. I can take him to this place today, and that's got to happen. That's got to be, I need some kind of conditions. There's no way I'm sending him home to mom, but he's not getting it without knowing he's going to get services there, because what's the difference of that being here or there? At least here, there's some kind of oversight on him where he's not going to be going off, so.
But here, my argument is here isn't working. So.
I understand that, but we don't have an alternative right now, Ms. Abels. So we can go back and forth about this all day, but there's no plan in front of me right now any better at this time. And I would love to have one because I'm convinced that he needs it. So, but that is my order.
Thank you, Judge.
Rudy Valle.
Your Honor, for the record, Rudy Valle, mom was not going to be able to be present this morning. However, we have grandma, who is also part of the decision making at home. And this is
Hi, Mom.
Sonia.
That's okay.
Go ahead.
Okay, yeah, Sonia Teach. Okay, Mr. Valle, this is your 10-day detention hearing, and we have to see you every 10 days to determine whether we should release you to a parent or guardian or keep you detained. And you're level 2 outstanding, and so you're detained.
Ma'am, I also wanted to, that was a mistake. He went down for a timeout. It was supposed to be no points were taken. They put it down as a resident initiated separation, which dropped him to a 3, but he is actually a 1-0 today.
The 1-0 today, and how long has he been a 1-0?
I have no idea, ma'am.
It would have been 3 days.
All right, Mr. Valle, you right to remain silent. If you do speak, nothing you say can be held against you or any other kind of proceeding. I can only consider it for detention purposes. And your attorney is going to be Mr. Edgeniji today. I don't see Mr. Green. Lateef?
Here.
All right, thank you. Let's see, Mr. Valle, looking at your history, 3 days level one outstanding is not good enough. I don't have that. Mr. Reyes, what's the deal with this behavior level?
Okay, on his behavior level, I don't have much info on that, but I do know that since he was detained back on the 7th, he has 23 level 3s. So he just, if that was the, if he had the opportunity to be at level 2 and now he's at 1, he would have been only 1 day or 2 the most.
All right, thank you. You're detained, Mr. Valle.
Your Honor, may I be dismissed?
Yes, thank you, Mr. Reyes.
Thank you.
I believe Judge Kim will take the remainder. Please do not bring in the next juvenile.
All right, thank you. All right, so in compliance with Texas Family Code, Chapter 54.08C, there's a presumption that all court proceedings involving children under 14 years old should be closed to the public unless there's good cause not to. This court, being unable to find good cause to keep these proceedings open, will now discontinue the live stream on YouTube. And there's a 20-second burn off.